I would like to begin by acknowledging that this conference is being held on the lands of the Wurundjeri people, and I wish to acknowledge them as traditional owners. I would also like to pay my respects to their elders, past and present, and Aboriginal elders of other communities who may be here today. Wominjeka. There is a sense of fear in our community. It is driven by many things: international enmity among superpowers and rapid climate change. Closer to home, the burning of our forests, the drying of the land, and COVID-19, the pandemic we are locked in with by the ring of steel. Our legal community feels these fears and uncertainties, and perhaps our young lawyers feel these things most of all. You feel the vulnerability of short-term contracts, a difficult labour market, and ever-increasing financial pressures. In this opening speech, I want to speak mainly to those young members of our profession in the room about these challenges. I want to say to you that you do belong to a noble profession, that by upholding its values, you will find certainty in confusion, strength instead of fear, and build something more worthwhile than individual gain. But to understand that theme requires an examination of the past. In 1990, Australia was entering the recession we had to have, so described by the Honourable Paul Keating, the then Treasurer, after also claiming that Australia was heading towards banana republic status. Here in Victoria, the recession was steep. Cranes no longer filled the sky, as John Cain, the Premier, said. Unemployment rose to 11%, and that for recent graduates rose to 17%, and record high interest rates pushed homeowners and businesses to the wall of bankruptcy. Amongst this situation, a seminal case was wending its way to the High Court. It had started in 1982. The Queensland Government, by legislative amendment, sought to stymie it completely. The claim was amended, and it was pleaded by the plaintiffs that the Queensland Government's intervention was inconsistent with the Racial Discrimination Act, a Commonwealth statute, and was therefore invalid. 10 years after it was commenced, the High Court published its seminal decision in Mabo and the state of Queensland. It changed the way Australian history was viewed forever. It was a case brought primarily by one man on behalf of a people, Torres Strait Islanders, Meriam people. He claimed that Australia was not an empty land at the time of European settlement and that his people remained entitled to land rights associated with their land. That case was a common law case run by a small firm of lawyers using Victorian counsel who acted pro bono. All this in the middle of a recession, which was eating at the stability of the Australian community. Can you imagine what would have happened if those lawyers had been defeated by the uncertainty of their times and simply given up? But why start here? What is the relevance of this case to the many of you listening today? First, I would like you to recognise that barristers do take cases on a pro bono basis, and you should ask them. But seriously, I take from this case that even in times of tremendous uncertainty, internationally the collapse of the Cold War, and domestically the very deep recession with its very significant impacts on young law graduates, lawyers persisted in the face of state opposition to bring and prosecute a case of great importance. That is the nobility of the profession. Second was what came from the Mabo case itself. It was litigation which sought to build on the notion that Indigenous Australians had a vibrant family and social life that should not be destroyed. In the language of the common law, these cases became known as the stolen generation litigation. They were cases taken both by Slater and Gordon, but more famously by Holding Redlich here in Melbourne. Those cases would culminate in the decision of the full federal court in Cabillo and the Commonwealth of Australia. The case involved young Lorna Cabillo, a child of 8 years old. She was an Indigenous person born at the Bunker Bunker station north of Tennant Creek. She was taken from her family and sent to boarding schools and foster homes as part of the state policy of removing Indigenous children to promote their assimilation. She lost her case at first instance, and she lost again on appeal. Undeterred, she made application to the High Court for special leave. She was not successful, and special leave was turned down. Behind that one case stood over 700 writs issued by Holding Redlich for other people in the same situation. What enormous cost. And in the end, perhaps, on one view, what an error of judgment to bring cases which ultimately failed time after time. But also, on the other hand, what tremendous courage to battle for a principle despite overwhelming odds, to expose a policy which had caused so much harm. That is the strength of the profession. And this case is also a reminder that even out of mistakes, the pursuit of valuable principle is ultimately valued. I note, on a side note, that the barristers there worked pro bono as well. And then we have the more recent case of Love and Toms, decided in the High Court this year. It was a case run by Maurice Blackburn. Here, the question was whether Indigenous people could be deported by the Commonwealth as aliens. Love, who is a recognised member of the Kamilaroi people, and Toms, who is a native title holder and a member of the Gungari people, brought action to say that they could not be deported from Australia. The High Court found in favour of the principle the plaintiffs argued for, that Indigenous Australians can only ever be Australian and could not be alien to this land. It is an important principle to be decided. It was an important principle to fight for. And like all the cases I have just described, whether they ended in victory or not for the plaintiffs, they helped build something important for the fabric of our society, a recognition of the unique place Indigenous people have in Australian history and culture. But why is this? Why are these cases important, and why are they important to you? In Victoria, it is likely we will be the hardest hit by the recession. Jobs in the legal sector will not be immune. Currently, 35% of the legal profession is aged in the bracket of 25 to 34 years, and they will likely bear the brunt of layoffs, as in the last recession. Even those people with jobs feel the impact of the recession. Ever-rising KPIs and billable hours, the need for more marketing, the ever-increasing need to be on call 24/7, and the simple fact of longer hours at the desk, either in the office or at home. It can seem an overwhelming ask, and one that leads inexorably to burnout, but it need not. Ask for help, turn to friends and colleagues. I would remind you that the law is a profession that does care for its people, though at many hurdles it may fall short. But at this time, I would also ask you to remember where you are and what got you to this point. Those skills and adherence to the values of our profession will, I believe, help you for the rest of your career. I would make the following points to you as you embark on the early stages of your careers. First, understand that the job title that you hold does not define you. The skills that you have will. That starts by listening to the people that you represent, individuals, those hurt at work, injured on the road, or suffering from a dust disease. It is not just a requirement of your job. It is a privilege to be afforded that insight into someone's life. But it is afforded to you so that you can properly tell their story. You might feel at present that doing work cover or TAC cases, appearing in the magistrate's court or the county court, is boring or even trivial work, far removed from the High Court. But taking instructions and doing a proof of evidence in these cases is no different in the end to preparing to tell Lorna Cabillo's story of being taken from her family at the age of 8, being isolated and alone, and speaking up for the entire stolen generation. Sadly, Lorna Cabillo died earlier this year. Second, understand that you have an important role in the community, the role of upholding the laws of our society for the protection of those in need. Whether it is Arnold Thomas and Becker representing workers on Manus Island, Robertson Gill representing victims of overzealous policing, or the many of you involved in advocating for the victims of sexual abuse, every case for every person you represent involves an application of the law as a sword or a shield. Both are powerful weapons in our community, but very few can wield them. Lawyers earn this privilege, and it is important to remember why and how. This starts with the basic skills that we obtain in our time at law school. We are a profession of critical thinkers, needing to think deeply, to dissect ideas down to their core in order to formulate arguments for our cases. And we then have to work in detail, slavishly for long hours often, to find the best way to present our client's case. The starting point must always be your case theory, that broad and flexible blueprint that begins imprinting itself on your mind as the client tells you their story. Spend time at this step and it will pay off. When I was starting in practice, I worked in a plaintiff's work cover injuries practice in Footscray. Peter Gordon, a person with vast experience in individual and class actions of real complexity, would always say to us that the plaintiff's best asset in any case is the plaintiff themselves. He would emphasise that we ought to spend time with them to understand what the case was about. It is easy to think in high volume, no win, no fee practices that simply pushing cases down the pipeline to settlement is the important thing. But I do not think that it is. Why? Because it is not why we are lawyers, and it is not in the best interest of the client who you represent if you do not know their story well enough to tell it properly. In court, practitioners who know the facts of the case and have a case theory stand out. They simply do. Those on their feet who struggle with the detail and have little idea of where the strengths and weaknesses lie cause delay. They obscure the real issues and, quite frankly, annoy the judge. But there is another more significant advantage to maintaining your professional obligations, and it is the broader job market. Lawyers are flexible. We are accountants, journalists, recruiters, management consultants, and of course politicians. The list could go on. It is why lawyers outperform STEM graduates when it comes to the percentage of graduates who find work within 4 months of graduation. This is why, of all the professions, we are perhaps the one profession which possesses the highest number of options. To maintain and further that success in the current environment means maintenance of those standards which I have discussed, to think critically and to act in the best interests of your client. And by doing the basic things, listening to them, and then working hard. Learning those things takes practice, takes time, and often involves mistakes. Do not be deterred. Everyone in the profession understands these things and forgives them. Even cases like the Stolen Generations case involving Lorna Cabillo, in which the court found against the plaintiffs again, and again, did not hold back the careers of those involved on behalf of Lorna Cabillo. Jack Rush QC, who led that case, and Melinda Richards, his junior, both went on to the Victorian Supreme Court bench. And from the instructors, Andrea Salamandras went on to the County Court bench. I want to tell you a story about a mistake that I made, which I hope helps you to understand the point I'm trying to make. The case occurred in the second year I was at the bar. I was junior counsel. The circumstances involved a young woman, Samantha Gosling, enjoying schoolies down at Lawn. After going to the pub one night, she was making her way back to her campsite. To do so, she, like so many others, descended a grass embankment opposite the pub. On her descent, she lost control and tumbled down. She struck her head on a concrete drain and died. Nervous shock claims were brought on behalf of her 7 family members. She was the golden child around which the entire family orbited. It was a harrowing trial to run because of the emotions at play. Every day the family was there, distraught. At the end, the judge found for the defendants. We had lost. In our conference room immediately afterwards, the emotion was palpable. All 7 of the plaintiffs were sobbing, if not angry, and certainly bewildered by what had just happened. All of them looked at counsel, looking at us for the way ahead. And at that moment, I, in a moment of shame, began to cry. I was just overcome by emotion and my feelings of sadness for the family who had been through such an ordeal. My leader was not. He simply, calmly and clearly said to them that we would examine the judgment and advise them if there were grounds to appeal. It might be thought that an overflow of emotion is excusable at such a time. I do not consider that it is. There is nothing wrong in being emotional about a case or being empathetic, but there is a time and a place for a display of emotion, and it was not then. I've always looked back on that moment and considered it a grave breach of my obligations and a fundamental mistake as a lawyer representing that family. What they required of me at that time was not just a sympathetic shoulder, but they required a clear path forward with known variables. They required a shield to protect them from what had just occurred. I've always felt at that time that my leader showed me the way. He very clearly explained to them what the next step would be. That next step, though it had no ultimate promise of relieving their pain, was a certain one, and that certainty provided hope. It was an example of counsel displaying the best characteristics of our profession. Undeterred, he simply and clearly explained to them how we would move forward using the law as our guide. He displayed the strength necessary to fulfill his obligations to the clients. This strength is what you will need in order to navigate not just your life as a lawyer, but more broadly will allow you to succeed in many other areas of your working life. I would add that my leader forgave me for that error, as did my instructor. They both briefed me in the appeal. For that, I am ever grateful. But it is a lesson that I remember all my 16 years after the event in excruciating detail. It reinforces the point that I wish to make with you today, that if you uphold the best traditions of our profession, they will see you through times of great uncertainty. So as I began by saying to you, in times of great uncertainty, fulfill your obligations as lawyers, as counsel, and you will surely navigate this uncertain time. To paraphrase the words of the great Franklin Delano Roosevelt, as lawyers in this time, you have nothing to fear but fear itself.